live stream hung up. There it goes. Okay, Shannon, you could put us on the record. All right, looks like all I've got left are cases where we only have one attorney involved. So, Mr. Berlinski, which file are you here on?
Yeah, all right. I'm here on George Swihart versus Beatrice Drlicka.
All right, well, Ms. Drlicka.
I'm not sure if I'm pronouncing that correctly.
It's Beatrice Drlicka.
Beatrice Drlicka, okay.
Correct.
Well, ma'am,
Thank
your case is scheduled for a pretrial conference today. And what happens at a pretrial conference is the court determines is it necessary to hold a trial? So, Mr. Berlinski, why don't you tell me what this case is about?
Good morning, Your Honor. Brad Berlinski on behalf of the plaintiff. This is the first scheduled pretrial in this matter. This is what appears to be a real estate deal gone bad. The parties on their own were entered into a contract where plaintiff would pay defendant $30,000. Defendant would convey a 10-acre portion of her large horse farm to them. Plaintiffs paid $30,000 and they've received nothing in response other than more expenses, more attorney's fees, and defendant has failed to give them their money back, failed to convey the property. As outlined in the complaint, we have a fraud claim. This is, I don't know if she conned them or what. The answer is very vague and just general statements with no substance. We sent initial disclosures as required under the new court rules. We also sent requests for admissions. The admissions went unanswered timely, so they're deemed admitted. She later answered them, and she admits to receiving the money, admits to keeping the money. She makes the, I guess, laughable argument that to her knowledge, I acted to convey the portion of the property to plaintiff. She's conveyed nothing. All she's done is kept the $30,000 and refused to communicate, refused to return the money. This is a fraud upon the plaintiff, and we filed this action. We're going to seek attorney's fees as allowed under the law, and I would anticipate at this point filing a motion for summary disposition. I didn't have time to do it. I was waiting for the requests for admissions, the responses that didn't come timely. Now that those have been deemed admitted, I'm going to file a motion with the court's permission. I don't think it's even necessary to hold a trial. She took the money, she didn't convey the property, and now we need the court to assist us in our remedies. So I would ask the court allow time to file a motion for summary disposition and set the matter out maybe for a status conference thereafter or a pretrial.
So, Ms. Drlicka, I'm not sure how much of that you really understood.
I understand all of it, actually.
The claim is you were paid a sum of money for some property, and
yes, sir.
You still have the money, but you've never conveyed the property. Is that correct?
No, that's not correct. No, I've done everything under the contract that we originally signed. So I did everything. I believe it's Exhibit A. I'm not positive, but there is a document in there with a quitclaim deed. I have done everything to fulfill that document. I have not committed fraud, however, and I would not, ever. So that's where I'm at. Now, all of a sudden, they didn't want the property.
Hold on a minute, ma'am.
Yes, sir.
This Exhibit A is not a conveyance. It's an agreement to convey.
Okay, wait a minute. I've got to grab my paperwork. I'm not a lawyer. I'm just trying to do this in a very civil way. Hang on. It's a quick claim deed. So,
No,
Mr.
it's not, ma'am. I'm looking at it. It says it's a contract for sale.
Okay, hang on.
That's not a quit claim deed.
Okay, okay, wait.
If you had given a quit claim deed, you wouldn't be here. You
I
wouldn't be
did give
sued.
I did give a quick claim deed. So maybe I have
Do
not.
you, do you have a copy
No,
of
I
it?
did. It's signed and everything by
You-
everybody and notarized. And that was back on April 1st. I did a quick claim deed to Shelby and her father George and Patricia
Ma'am,
Swihart.
okay, ma'am, listen to me. I'm looking at the document right now. It's dated April 2019.
Okay.
It's signed by both parties, all
All
parties,
parties. Yep.
and it's notarized and
Correct.
witnessed. But
Yep.
I am telling you, ma'am, that is not a deed. That is a contract where you agreed to sell and they
Yes.
agreed to purchase,
Yep.
but you can only complete a sale of land by producing a deed. Are you willing to execute a deed to convey this property?
They don't want the property now, Mr. Honor. They don't want it. They
All
want their
right, well,
money back.
I'm not gonna deal with this anymore today. You're scheduled for trial. Mr. Berlinski indicates that he wants to file a motion, which I'm going to allow him. I will adjourn the trial for 1 month. Mr. Berlinski, that should give you enough time to get your motion filed.
And so I will
And
get
ma'am,
an attorney.
I suggest you get an attorney and you do it quickly.
I will. I will.
All right.
All right. Well, you have a great day. Thank you
Is-
so much.
Is 1 month adjournment sufficient, Mr. Berlinski?
Judge, well, considering we have to give 21 days notice, but when it's ready for the hearing, that's cutting it pretty close with the holidays.
Uh,
But
Would you prefer 2 months
please,
or
Your
6
Honor,
weeks?
2 months is fine. I'm going to work on it as soon as I can, but we have to give proper notice.
All right, will do.
Thank you.
Thank you. Have a good day,
Thank
Mr.
you.
Licka.
Have a good day.
Have a good day. Thank you. Bye bye.
That'll be fun.
Peter, I'm sorry, I just got your.
Okay, and let's see. Mr. Fries, I have no idea what matter you are here on. Is this the matter of Richardson versus Fry? You're muted, sir.
Yes.
All right, Mr. Fry, I conducted the pretrial just with attorneys. I don't normally bring parties in for that. So you need to speak with your attorney as to what happened at the pretrial.
Oh, okay. Thank you. Thanks a lot.
Have a good day.